Let's bring in our guest for the hour. Alexis Rosenberg is a trial attorney. She's in Sarasota, Florida. What's your take on this Amish case?
Ted, isn't this so interesting? I can't remember the last time we had a trial having to do with the Amish community. So my take is this is a very interesting argument to say that he did not understand the Miranda, and I'm sure, some other factors. Although on the cross-examination, getting into you understood you had the right to be silent, I think was extremely important.
Oh yeah, there have been situations, Alexis, where we've had judges look at cases where there's maybe been a line missing in the Miranda warnings given to someone, and the judge finds that it's harmless because most people know the Miranda rights generally, even if some small part is missed. But here, I think this individual could make the argument that he didn't know anything about Miranda beforehand. He didn't really understand his rights. Do you think the fact that he's living in this community that really tries to separate themselves from the rest of society, that he has more of an argument than the average person?
Oh, definitely. I think it is a strong argument to be made that he did not understand, because the whole premise of that community is to separate themselves out, and he wasn't aware of these things. He came across as a very credible witness as well. He doesn't come across as extremely educated either, or understanding normal things as to what was being taken place. Although I do think one of the things of getting into that he thought he was going to confess and then just be forgiven isn't necessarily going in his favor, but having to do with this particular argument his attorney's making as to whether Miranda was appropriately administered or not, they made a good argument.
So would the solution, I guess, well, should the protocol be that in a case like this you have some sort of liaison between the community that is being dealt with through a potential defendant?
Like an interpreter.
Yeah,
almost
like bring in a person that's familiar with the Amish community and say, all right, here's the deal, dude. Don't confess, because out here, they don't just let you go back to work. It's a different ball game. It's to your point, it's fascinating. I don't know of any other sort of classes of individuals that live in the United States that obviously are subjected to the laws of the land that are in this particular sort of situation. Because, we know Miranda rights, whether you watch court TV or not, you've heard it a gazillion times. You have the right to remain silent if you watch anything on television or here and there. This guy didn't have that.
Right, the police don't have an obligation to have any sort of liaison, as you're talking about. That would have been him asking for counsel, but we're saying he didn't understand he had that right. I mean, this is kind of a tricky thing, because then we could also balance it with somebody who maybe has a lower IQ in general, regardless of the fact that they aren't Amish. I mean, where is that breaking line as to where you have the ability to comprehend, you are competent to stand trial, but you didn't understand Miranda? This is extremely fascinating. It'll be interesting to see what the judge does.
It's just the death penalty laws changed in Florida following the Parkland shooting trial for Nicholas Cruz, and there no longer is a 12-0 majority needed, unanimous for the recommendation. And in this case, it was 8-4. So 4 jurors did not want to recommend the death penalty. Do you think moving forward, none of the people that have been convicted and sentenced to death without the unanimous decision have gotten to that point yet, but do you think the federal government's going to allow an execution of someone like Jose Escalera because of that 8-4 instead of 12-0?
Ted, you're absolutely right. Florida's kind of had you have a whiplash going back and forth with what has been happening with the death penalty in Florida. I mean, there was a case before that it was found, our death penalty was found to be unconstitutional, and now we just had this shift that we can do it 8-12, and we also have the Spencer hearing. So I think the situation with him is, I do think the judge is going to go with the jury, and he's going to sentence him to death. I think the case that you brought brought up previously in the previous segment, that hinged, I really believe, on the fact that the defendant or the judge believed the defendant has some intellectual impairments or disabilities related to that. And I don't think, unless we hear otherwise, that is the situation in this particular case. So no, I don't necessarily think that anybody is going to necessarily overturn, unless something comes out in Florida and it's found that the 8 to 12 isn't constitutional now. And who knows? Like I said, it's been whiplash having to do with the death penalty laws in Florida in the last decade.